Most of you all know me, Philip Hundle. I'm an attorney. What a lot of folks didn't know about me is I do practice condemnation law on the landowner side. And folks that know me thought, oh, I thought you did more probate litigation, commercial litigation, civil litigation. And how this started for me was, many years ago, I had former clients call my office and say, hey, Philip, I'd like for you to take a look at this easement, pipeline easement. Okay, great. I'd like you to work on the terms of it for me. Okay, great. Yeah, they told me one thing, but it really looks like it says something different. And so I'd like you to take a look at it. And then when I looked at it, they had already signed it. And it frustrated me because, unbeknownst to them, they had signed something that they didn't really know what they were signing, and they needed help with it. And I've seen some statistics, and I don't know if these are true or not, but I've seen statistics from other lawyers that do condemnation work that say, 60 to 80% of the landowners that are subject to a condemnation project sign the first document they get and take the first offer they get. And we'll talk all about that, but that's why I have, I started doing this type of work. I enjoy this type of work. I do a lot of other land litigation type work, partitions. I think everyone knows families that, own land and then they partition the land because, through the generations it passes down and you have undivided interest. And so I do a lot of that work as well. Some of you all know that I'm an Aggie. I'm a big Aggie football fan, and so I'm getting excited about the upcoming year. I'm from Wharton County. I'm from here. I grew up in Wharton, now live in El Campo. I'm from the county, and these are projects that affect the county. So it's near and dear to my heart. Let's talk about what kind of projects are condemnation projects. So the typical, we're here to talk about some pipeline projects. Yes, those are real common, especially common here in the Gulf Coast area. If you look at a map from the Texas Railroad Commission, it looks like a crossword puzzle, lines everywhere. So there's pipelines that cross the Gulf Coast area going to the coast, primarily Corpus, Sweeney, Freeport. So lots of pipelines, and there will continue to be lots of pipelines. Highway projects, we're starting to see, obviously, the expansion of Highway 59 through, from Fort Bend County through Wharton County, and it's going to continue south. So they changed the name of the phases, but I believe they're finishing up phase 1, going to start phase 2 of the Highway 59 project. I'm handling some of those condemnation matters on the highway expansion, okay? And those are, the state of Texas, right? TxDOT is taking property along Highway 59. The difference in the pipeline and the highway cases, they are taking a fee simple interest. They're not getting an easement, they're taking the land to permanently be part of the highway in the state of Texas. The pipeline cases, most of the time they're acquiring easements. What is that? And we'll talk more about that, but they're acquiring a right to do something on your property, but you still own the land. You still, and I won't even say technically own the land, you own the land, but you're subject to a right that they have, and their right is to run a pipeline on your property. From time to time, we'll see pipeline companies want to acquire and try to acquire fee simple interest. In other words, your actual dirt, your land, for valve sites, compression sites, things like that. Power lines, yes, from time to time, not as talked about, but quite a few pipelines, run through this area. We have the South Texas Nuclear Project, and so there's lots of power lines running from the South Texas Nuclear Project. LCRA, as you'll see, on the miscellaneous, there's other miscellaneous categories of condemnation projects, from canals, water lines, sewer lines, municipal water sewer lines, things like that. Drainage projects. I have LCRA mentioned because LCRA from time to time will have condemnation matters on canals, acquiring the right to own a canal either in fee simple or an easement. And LCRA, as you know, also has dams on the Colorado River that create power, so they also have power lines too. All right, next. Yeah. So this is just one of the many maps that you can find and that I've seen of some major pipeline projects. This doesn't include a lot of the smaller pipeline projects in the area, but these is just, you know, a look at the statewide projects. These are the main ones, as you can see. You know, the one that says P66 Enbridge, that's the Gray Oak line. You know, all these pipelines essentially originate from the Permian and come to the Gulf Coast, either to Mount Bellevue, Freeport, or Corpus. Next slide. So specifically, the Gray Oak, you know, these are joint venture projects normally among many corporate companies or corporations. They're you know, a huge investment, a capital investment by these companies, so they like to share the risk. Phillips 66 and Endeavor are the joint venture partners in the Gray Oak. Enbridge, as you saw, was mentioned because it has an option to be part of the participation. And the completion, I always say these are somewhat moving targets, but you know, their latest news release says, you know, end of 2019 for the Gray Oak pipeline. I've seen numbers of estimated investment in the Gray Oak line of $2 billion. Recently announced, yeah, they expect to spend $2 billion building, and the capacity is 800,000 barrels a day. So that's the Gray Oak line, and then and here's a picture of the Gray Oak line. Next slide will also show, I'm showing this because the Sandhill, DCP Sandhill line, the Gray Oak essentially runs parallel to that. Okay, so if your property is affected by the DCP or was affected by the DCP Sandhill line, you're probably going to be affected by the Gray Oak line. So now let's back up to the other slides. One more, yeah. And then the other one that maybe you've heard about, maybe you haven't, it's called the P2K, or Permian to Katy line, and it looks like I misspelled Katy without a T. It's a joint venture with Sempra and Midstream and even Boardwalk Pipeline Partners. Maybe Boardwalk, you know, is a name you're familiar with because they had a pipeline several years ago that they constructed in Wharton County called the Gulf South line, or the Coastal Header project, and that's the Boardwalk partners. So they're looking to complete this P2K line third quarter, or end of 2020. Let's jump back now to the map of the P2K line. So that's what the P2K line looks like. So from the Permian to Katy, and but it splits off and joins this coastal bend header of the Gulf South line. That line runs through the Egypt, Lissy area, down through Bowling, Pledger, and then on to Freeport. So those are the, there's another project I didn't mention, but you've probably heard of this one. It's called the Epic Y pipeline. Not going to come through our area here, but it goes to Corpus, and there's lots of buzz about that because that's going to be a huge capital investment by those companies. So the right to condemn, this is actually something that was brought up by one of you this morning, and we can talk about that. The state, right? Who's the state? Well, the state of Texas, the city, the county, they have the right to condemn, to take your property. The power is eminent domain, and the process is condemnation. Quasi-governmental organizations, the best example I can give, and I have several cases, I've dealt with the LCRA, is the Lower Colorado River Authority or other river authorities, the Brazos River Authority, the Guadalupe River Authority. So those are quasi-governmental organizations. They operate on their own. They have a board of directors, but those board of directors are appointed by the state legislature or the governor, approved by the state legislature. So not to forget about quasi-governmental entities. And then private for-profit companies or entities, just what we mentioned about with pipelines, they have the right of eminent domain. They have the power of eminent domain, and their reasoning or the authority in which they get that is because it has been the work that they're doing or the projects they're doing, it's for infrastructure and it's for a public purpose. We could spend all day debating whether it is or isn't for a public purpose, but it has been established in most cases that a pipeline transporting petroleum products or natural gas is been found and shown to be for a public purpose. There's been lots of litigation over the last several years over some famous cases. It's called the Texas Rice case that talks about, well, is it or isn't it for a public purpose? But for our purposes today, we're going to assume that these private entities, these pipeline companies, will have the power of eminent domain. For pipelines, you'll hear and see about a T4 permit, a check the box railroad commission permit. That's a permitting process they have to go through, in the condemnation or to acquire power of eminent domain to begin their pipeline work or to acquire an easement or fee simple interest through condemnation. So, next slide. I put this in here, this slide. I want to talk about right-of-way agents. Why? Because that's going to be the first person that you probably encounter. So, as landowners here, you go to the mailbox and next thing you know, you have a letter in the mail or you have a phone call from someone asking you about the letter that you probably haven't even gotten yet, but you will get soon, and that person is a right-of-way agent. I know lots of right-of-way agents, and for the most part, they're good folks. Unfortunately, like with anything, there's a few bad apples sometimes, and those right-of-way agents, I always like to warn landowners, be careful, and as you see on the bottom of the slide, I say be careful with right-of-way agents in your communications with right-of-way agents. Understand that just like, as a lawyer, I have a client that I represent, the right-of-way agent has a client that they represent, and they represent the pipeline company. They don't represent you. Sometimes they want to play good cop, bad cop, and they're the good cop, and the pipeline company's the bad cop, or they want to seem like they're a neutral or a mediator or facilitator. But make no mistake, they have a job, and their job is to acquire the pipeline easement from you. Their job is to get you to sign the easement document and come to some agreement on payment, monetary payment. Their objective also is to do that as cheaply as possible. So I always equate them sometimes, their tactics to, we recently went car shopping and, some salesman said, hey, take a look, no pressure. And we did take a look at lots of different models of cars and there wasn't any pressure. Other guys, they seemed like they were right behind us, on our heels, and I felt the pressure, right? So many right-of-way agents do put a lot of pressure on landowners. I think it's a tactic that actually doesn't work, but some of them don't know that still, and they still try it. So, they also, and this is not a generalization of all right-of-way agents. I'm going to repeat, I work with right-of-way agents all the time, and most of them are very professional, and I don't have a problem with those. But however, many of them, or some of them, I have, come across misrepresent what the easement says and what the easement will do to the landowner's property. Or, like in my original example, how I became very passionate about condemnation is they promise the landowner, don't worry about it, we'll fix it later. Or sign this one, and there'll be some other version, I guess, that you sign. I was very confused by that, but once again, that was to me a false promise. And there's, don't rush to sign. Part of the strategy is, and what the right-of-way agents will say is, well, if you don't sign now, we're going to file against you. The pipeline company will sue you. Yes, if they file against you, they are suing you. It's a condemnation action. That's not a misrepresentation, but the very fact that you have to hurry up and sign, or bad things will happen to you, that's not always the case. So don't rush. Don't feel like you're pressured to sign or rush to sign. So with right-of-way agents, can you talk to them? Sure, talk to them. I always say it's better to listen sometimes than talk. Also, always be careful with setting a certain expectation or letting them know what your expectation is. And why do I say that? Because I don't, early on in the process, I don't think you may have all the information to be able to set an expectation of what you should or shouldn't receive. So, and we'll go into that in a minute. So next, the do's and don'ts of negotiating. And so, do reject the first offer and the proposed easement agreement. So I can flip that around and say don't accept the first one, but I'm saying do reject it. So reject it. Don't provide information to the right-of-way agent because you don't have to. And they love to ask you about the land and the productivity of the land and valuations of the land, and if you've had valuations done recently, or you name it, they want more information. Why do they want more information? Because they want to be able to prove to you why you should accept their number. Okay? Don't agree on a monetary number first, and I'll explain why. Do work on the non-monetary terms of first, of the easement agreement. Then focus on the money. And don't rush to sign. Sorry, I'm going to say that multiple times, but don't rush to sign something. Next. Key terms of the easement agreement. Why focus on the non-monetary items first? Well, if the pipeline company, the first version that you will see, and you've all seen the first version of the proposed easement agreement, it's very pipeline friendly. No surprise. Shouldn't be mad. Don't be mad about that. You shouldn't be surprised. The pipeline company wants a very favorable easement. Now, this is where the work starts, right? We start marking it up, and as a landowner, mark it up, so that when you do go speak to a lawyer, and I recommend you speak to a condemnation lawyer, but when you speak to a lawyer, or if you choose not to, but you want to speak to the pipeline company or the right-of-way agent, you've got notes on things you want to change. So mark it up and work on the non-monetary first. So think about what the document says, look at what the document says, and first and foremost, what's the easement look like? Is it a specific easement or a blanket easement? Nowadays, I'm going to say, they're probably not going to be a pipeline, a proposed pipeline easement that there's going to be a blanket easement. What about, let's look at pipeline easements from the 50s and the 60s. Those were blanket easements that said, 50-foot right-of-way across this tract of land. They weren't specific on where that pipeline was going to go. So make sure it's not a blanket easement. The non-exclusive easement or non-exclusivity, make sure it's not an exclusive easement just for Phillips 66, but a non-exclusive. Therefore, other things could go in that easement area. Other pipelines could go in that in that easement area. The easement width, obviously, you want to determine that, and that's something you can negotiate sometimes. Limit the number of pipelines. Have I oftentimes seen pipeline companies or the LCRA or other water authorities attempt to put more pipelines in an easement? Of course they have. Have they limited those when pushed? Oftentimes. Limit the type of products that can run in the line. Of course, a pipeline company will want the flexibility to be able to run anything through the line that they want. Well, try to narrow that down as you can. So as you can see, we're trying to narrow and restrict the terms of the easement as much as possible. Limit the pipeline diameter. the pipeline company initially, of course, knows the diameter of the pipeline, but I like to limit that so that in the future they don't attempt to place a larger pipeline there. And if they do, then obviously you're back to negotiating on increased diameter. Depth requirement, this is something big, and there's a long list of all different key terms in an easement to go over. These are just some of the highlights, and I've got more on the next slide. But the depth requirement, we're always concerned about that because of farming. I think a standard rule of thumb, most pipeline companies will say 48 inches, no problem. But what if you want to do something more on the property than just farm or run cattle at some point? You may want that pipeline a lot deeper, 60 inches or more, right? They're going to have heavy traffic over it. Other key terms that I like to highlight and mention is, what about, surface facilities? A lot of times these pipeline easements will allow pipeline companies to do all sorts of things on the surface as well. And the landowner doesn't think about those possibilities in the future. And it may not be part of the original engineering schematic or diagram or plan or project. And then next thing you know, if they have the flexibility or option to put surface facilities in the easement area, they may decide to do that. So be careful with that. If they, do plan on putting surface facilities in the easement, then, that equates to more money. So reserve the surface use. Make sure that you can still use the surface for as many things as possible. I've oftentimes seen easement agreements that, and these are easement agreements that we were in condemnation over, they filed suit and we were still arguing about allowing us to do something over the easement area, being able to cross the easement area. So they had very onerous proposed easements. Double ditching, you all, I believe, know about this. It always surprises me when I'm discussing or cross-examining, the engineers of these projects, and I say, is the pipeline company going to double ditch? And they go, well, what's that? We don't know what that is. I mean, and even in oftentimes in their easement agreement, it will be in there. But the double ditching is, taking the topsoil and putting it on one side and taking the undersoil and putting it on another, and then putting it back the same way, where you don't have, good topsoil, deep down in the ground 4 feet. So add additional provisions for extra damages. So, if there's, damage to your cattle, they injure cattle, they kill cattle, cattle fall in the trench, have some damage provisions for that. What am I talking about? Well, if you just run commercial cattle, then, to avoid a fight with the pipeline company on what's the value, you can establish the value. If it's registered cattle, establish the value. So things like that, you can establish the value in the easement agreement. Require restoration, in the easement agreement. Most of the time what we push for is, put the surface, or put my land back to the same condition it was before you did what you did to the property and dug the trench and put the pipeline in. So the restoration part of it. Specify fencing and road repairs. You can be as specific as you want. There's some language that we normally use on fencing, that it needs to be braced in a certain way, barbed wire, the type of posts, things like that, so that they're not putting steel posts in if you want cedar posts back in or whatnot. So the road repairs, it can be, restore the roads to the condition that they were, or add a certain amount of caliche or gravel or whatever, so many inches, or regrade the roads. The termination of the easement. Someone here this morning mentioned about that. These easements, very, very seldom will a pipeline company enter into a term easement with you. They will want a perpetual easement. However, it is very common and usual to push for and ask for a termination of the easement if that pipeline is not used for a certain amount time. So if the pipeline's not used for 2 years, 3 years, then the easement terminates. And I put this in because oftentimes if there's disputes over the easement agreement, the pipeline company or the condemnor, right, will want arbitration, an arbitration provision of any disputes. And I prefer not to go to arbitration. I prefer to go to the courts. And, we have a very fair court system that allows for you to have a jury trial if you wish to have one. In an arbitration, you're in front of a panel of maybe one decision maker, private decision maker, or 2 or 3 or whatever the arbitration provision calls for. Nothing against arbitrators, but if you ask me where I prefer to be in front of a elected judge or a jury. Damage calculations. We're not going to spend a lot of time on this because this is something that could take hours, but just in general, how are damages calculated? I know you all have heard about, well, they're, how much are you getting per foot, per rod, for this, for that, and those are all terms that are used in I'm going to say measures of damages or terminology of damages that are used with pipeline cases. No problem. But if your condemnation case goes, to the court, how are the damage calculations, or how are the damages going to be viewed and calculated? It's going to be, they look at what's the highest and best use of your land. They're going to, a judge or jury will look at what's the value of the part taken. So the easement is taken, that's being taken, or fee simple, whatever. And if it's an easement, let's just say for round numbers, hey, the highest and best use of your property is row crop. Row crop is determined that it's $5,000 an acre, and they're taking 1 acre of your land, fee simple. So arguably that's worth $5,000. If it's an easement, then they're not taking 100% of your 1 acre. They're not taking $5,000 worth of land from you. They're taking the easement, maybe it represents 90%. It encumbers your land a lot, so it's 90% taking. So it'd be 5,000 times 90%. That's how they come up with a part taken. Then you have to also take into consideration the damage to the remainder of your property. What does that mean? What's the value of the property before they take, my acre, and what's the value of the property after they take my acre? Pipeline companies very seldom, and we're talking about pipeline companies today. I should just say condemnors, the state, the highway projects, you name it. They very seldom like to calculate damage to the remainder. They like to say there is no damage to the remainder, and that's a component that needs to be calculated and figured in to come up with the total damages. So damage to the remainder is also a huge component that needs to be, or an important component that needs to be calculated in. And then I put in parentheses, and I shouldn't maybe, but it says additional damages for access roads and temporary easements. So you've all seen on these pipeline projects, so there's a temporary workspace, or if they're going to bore under a road, they obviously need more area for their equipment to bore under a road, and so they need additional temporary workspace. That's something that also, you should and most likely will get compensated for, is the temporary easements, and they only last for as long as the construction lasts, maybe 6 months after or 3 months after. And then the access roads. This should not be overlooked. A lot of times, a lot of focus is, well, the pipeline easement will be 50 foot wide, and we're going to pay you, we're offering you this much a rod. That's in the initial negotiation speak, and the access road is in a paragraph that no one even really looks at, but it's important to look at it because an access road, an easement, they're also getting an easement for a road to get to their pipeline. And that may greatly encumber your property. That may greatly reduce the marketability in the future for commercial use, or you name it. Also, that access road, many times it's not specified. So what does it become? It's a blanket easement. So in other words, they can access their pipeline, however they choose to over my property. Yeah, if that's what the easement says and that's the way it is, that's what you signed, then yes, the answer is yes. So be careful not to allow that to stay. So you want to specify if they are going to have an access road to their pipeline, and that's something you're agreeable to, you negotiate the terms, make sure you specify where that road's going to be. So key part. Also, to just touch on it, it's not on the slide, is if there's going to be some damages to crops, it's turf grass, pasture, you're not going to be able to use that pasture for 1 or 2 seasons, or hay, then you want to get compensated for that as well. So attorney's fees and expert fees. Want to talk about this because many people don't know this, and you need to know this. And this is where I think there needs to be some legislative work in condemnation. There's been some attempts by landowner groups, but they've come up against a lot of more powerful, more, I guess, deep-pocketed groups of condemnors. But you don't get, if you don't reach an agreement with a pipeline company and the pipeline company takes you to condemnation and you have to fight them in court over the value of what they're taking and the value of your land and what they're taking and how they're damaging your property, you don't get to recover attorney's fees. And you don't get to recover your expert fees. Well, why would you need an expert? Well, you need an expert to be able to show the value of your land, the highest and best use, the damage to the remainder. You're going to want, an expert to help you with that. As a landowner, you can testify to the value of your land and the damage to your land, but you will also want an expert to help you. You don't get compensated or reimbursed for that. And I think that's unfortunate because, who has more money, the pipeline company or the landowner? 20 states allow some type of recovery of attorney's fees or expert fees for the landowner, but not Texas, not yet. So something to think about, and if you hear, something about it, pay attention. And if there's some support you can lend to that, that's, you decide. But next slide is now, let's talk about, how do attorney's fees work in your case? If you choose to hire an attorney, how does that work? Well, you can hire a lawyer hourly or on a contingency fee basis. Most landowner condemnation attorneys charge or work on a contingency fee basis. I handle cases both ways, hourly or contingency fee basis. The contingency fee, and I'm going to say, I'm speaking to what's the norm or what's usual. I've seen all kinds of arrangements, but normally it's the contingency fee of the lawyer that's going to be earned by the lawyer, paid to the lawyer, is above the initial amount you were offered. So if a pipeline company offered you, $20,000, then anything above $20,000 that the lawyer can get for you, that's going to be split between you and the lawyer. Split depends. What's the rate? Anywhere from a third to I've seen up to 45% on as the attorney's contingency fee. So simple math. Let's say your initial offer is $20,000. The attorney is able to get you $80,000, so that's $60,000 more above what you were initially offered. So if you're at a 1/3 or 33.33%, then the attorney would get $20,000 and you would get $40,000. So 40 plus the original 20, and you're getting $60,000 total, and the attorney's getting $20,000. So pretty simple math, but it's important to discuss. As a landowner, you can say, well, I want to negotiate that amount down. No problem. I would suggest you try to negotiate everything down, or I'm going to say, let's not make it the initial offer, let's make it some other number. Well, I think in the end, you know, if you try to make it a number higher than the initial offer, then the attorney will probably say, well, let's do a higher percentage rate. So, you know, it's, at the end of the day, I think you want to do what, you know, is fair and what you both feel comfortable with. I like the contingency fee arrangement because it makes me as a landowner condemnation lawyer work harder to get you more, because then I receive more. So there's definitely a built-in incentive for me. Who pays for experts? I say this because I want you to know, you know, if you do talk to a lawyer, and you know he you know, under any contingency fee arrangement, there has to be an attorney fee agreement, and so pay attention in the attorney fee agreement to how are the experts paid. The expert fee can come off the top. It could come out of your part of the settlement. It could come completely out of the lawyer's part of the settlement. You just need to know what it says and what the arrangement is. Next slide. So this is the part where, you know, this is all good information, but you know, at the end of the day, Philip, what do I do? What should I do? And first, you know, if you receive that letter from a pipeline company or a call from that right-of-way agent, we've already said, you know, listen more than you talk, okay? Document your land. Document the characteristics of your land. Know the important features of your land. Take pictures. You know, are there fences? Are there trees? Are there trees that are going to be affected by this pipeline or not? The pasture, is it improved pasture? Is it not? Cows, is that going to be an issue? Other improvements, you know, are they running the pipeline through a barn, through a building, right next to a building that the city requires a setback, so therefore the building's going to have to be demolished? I mean, all things that you only know unless you know your land real well. Now you may say, well, of course I know my land. Well, some people, you know, have quite a bit of land and lots of tracts of land, and they're maybe not real familiar with exactly where that pipeline's going. Also, one of the first things I do is I say, please mark where the easement's going to go, where the pipeline's going to go, so we know. I can't tell you the number of times where, honestly, we all thought it was going to go one place and it actually was over a little bit. So, and it affected more trees or fencing or cattle pens, or you name it. You know, the pipeline letters, plans, plats, schematics, diagrams, you know, the things that they send you, keep track of it. I know it's kind of a no-brainer, but sometimes, you know, we're scrambling to try to find things that were sent, and we're, as lawyers, asking them to resend it because we've lost things or the client's lost things. Keep notes on the conversations and the comments of the right-of-way agents and pipeline reps. That's all. Just more information. And then, you know, go talk to a landowner condemnation attorney. You know, don't want to talk to me? Don't talk to me. Talk to some other landowner condemnation attorney. But go talk to some attorney that understands condemnation, practices condemnation, so that you're better informed. Does that mean go hire him? Maybe, maybe not. Go talk to several and see which one you're more comfortable with. So with that, I think that wraps up everything. I appreciate your time, and I've tried to give you just a few things to think about. I go to a lot of legal seminars, and sometimes they bombard us with 50 or 60 things to remember, and I always think if I can remember at least 2 or 3, hey, it's been a successful seminar. So I think if you can take away a couple of these key points, I think it's been successful. So I appreciate your attention. Thank you very much. If you've got any questions, happy to take those questions now. If you want to ask me questions later, you can call me, email me, you name it. So.